TikTok is banned. The Supreme Court refuses to stay the execution of the law that, effective January 19th, forces TikTok to be sold to a US company or to shut down. You might have seen customers react to the US government trying to ban TikTok over concerns that its Chinese parent company could exert too much control and provide information to the Chinese government by downloading a TikTok clone that is literally run by the Chinese government. How did we get here? Now, as you probably know, TikTok is a foreign-owned tech platform operating on American devices. Chinese technology company ByteDance launched the app in 2016. It now has over 1.5 billion active users, including about 150 million Americans. Now, many Americans make their living by making short films on the app, and TikTok's creators say that other social media platforms lack TikTok's organic reach and collaboration tools. Some have said, quote, they have posted the same content on other platforms for years, but only TikTok has fostered their communities and allowed them to reach broad audiences. Now, the people who serve in Congress generally don't grow up with social media platforms. The average age of a senator is 64, and the average age of a House member is 58. And that might be one reason members of Congress struggle with the implications of modern technology, which obviously is global. But for better or worse, the government is responsible for protecting the country from foreign threats, but it also has a duty to ensure Americans have civil liberties. Now, the courts traditionally defer to the federal government in matters of national security. And along those lines, on April 24th, 2024, Congress enacted the Protecting Americans from Foreign Adversary-Controlled Applications Act. The law prohibits the distribution, maintenance, or provision of internet hosting services for applications controlled by foreign adversaries. The act identifies China, North Korea, Russia, and Iran as foreign adversaries of the United States who are not eligible to purchase apps. The law officially bars Americans from using apps controlled by those countries. And the law requires ByteDance specifically to sell TikTok to remove, quote, foreign adversary control. And failure to comply results in a ban within 270 to 360 days. Now, the Supreme Court generally considers laws targeting specific speech as presumptively unconstitutional. In 2020, Donald Trump issued 2 executive orders banning TikTok, but the federal courts blocked both of those. So many legal commentators felt the new law was also on shaky ground. So when this new law was passed, TikTok and a group of its users sued the government, once again arguing that the act is an unconstitutional intrusion on free speech rights. Quote, by banning all online platforms and software applications offered by TikTok and all ByteDance subsidiaries, Congress has made a law curtailing massive amounts of protected speech. Unlike broadcast television and radio stations, which require government licenses to operate because they use the public airwaves, the government cannot, consistent with the First Amendment, dictate the ownership of newspapers, websites, online platforms, and other privately created speech forums. Now, TikTok claimed that it's an American company headquartered in Culver City, California, which means it has First Amendment rights. Thus, TikTok alleged that courts should apply a legal standard called strict scrutiny. Now, when it comes to reviewing government regulation, what level of scrutiny the court applies is usually the entire ballgame. When a court applies strict scrutiny, the government must show that the law is the least restrictive means of advancing a compelling governmental interest. And that is a very, very hard standard to meet. Strict scrutiny applies when a law regulates fundamental rights like freedom of speech. Now, normally when courts are reviewing governmental regulation, if it doesn't involve a fundamental right, the courts apply what's called rational basis review, which basically means if the court can find any rational basis for a particular law, it will uphold that law. Basically, any law that's reviewed under rational basis review is going to be upheld, and basically any law that's reviewed under strict scrutiny is not going to pass muster and then will be found to be not constitutional. And then there's a third option that's sort of a combination of the two. It's sort of right down the middle. It's called intermediate scrutiny. That's used when laws involve a right, but one that's not fundamental. Now, the US government argued that the act doesn't implicate the First Amendment at all. The government rejected plaintiffs' assertion that TikTok is a US company entitled to free speech rights because it's a subsidiary of ByteDance. And ByteDance, as a foreign company, does not receive free speech rights. But what about TikTok's American users? Well, the government claimed that the act doesn't regulate their speech at all. Americans remain free to say whatever they want on other platforms, and in fact, they would continue to be free to say whatever they wanted in a post-divestiture version of TikTok. The government argued that the court should use the rational basis test, which is the lowest level of review, and not surprisingly, the government argued for rational basis review. And as we talked about, the standard there is that the government's actions have to be rationally related to a legitimate government interest. That is an extremely, extremely low bar. The government can usually come up with a rational reason, meaning basically any reason whatsoever that is related to a legitimate government interest, meaning basically any governmental interest at all. All the government has to do is show that there's a hypothetical connection between the interest and the statute's goals. So this litigation went up on appeal. In TikTok versus Garland, the U.S. Court of Appeals for the District of Columbia upheld the constitutionality of the Protecting Americans from Foreign Adversary-Controlled Applications Act. Now, the first question for the court was what standard of review to apply. And the court said, quote, "We conclude that the act implicates the First Amendment and is subject to heightened scrutiny. Whether strict scrutiny or intermediate scrutiny applies is a closer question. The relevant portions of the act are facially content neutral, but the government arguably based its content manipulation justification for the act upon the content on the platform. We think it only prudent, therefore, to assume without deciding that the higher standard applied." Now, side note, what does a court mean when it says it assumes without deciding that a certain standard applies? Well, the court is declining to rule as a matter of law that a particular standard applies, usually because the outcome of a case would be the same regardless of which standard the court used. And in something that basically never happens, the Court of Appeals ruled that the government could clear the high bar set by strict scrutiny. Part 1 of the test is whether the government has a compelling interest. And the Court of Appeals said, quote, "The government offered 2 national security justifications. 1, to counter the PRC's efforts to collect great quantities of data about tens of millions of Americans, and 2, to limit the PRC's ability to manipulate content covertly on the TikTok platform. The former does not reference the content of speech or reflect disagreement with an idea or message." The court agreed with the government that China posed a, quote, "hybrid commercial threat," because it had adopted laws that enable it to access and use data held by Chinese companies. Now, does the US have any evidence that China has leveraged these relationships to access American data? Well, it's classified, apparently. Now, all this was appealed to the Supreme Court, and in the government's brief there, Attorney General Merrick Garland said Congress has received classified security briefings about TikTok. Theoretically, a court could have ordered the government to produce evidence from these briefings in an in-camera review, meaning a secret review, which would ensure the information was kept secret, but so far no court has asked the government to provide evidence of those briefings. So the national security threats are hypothetical. The government predicts that if the Chinese government asked TikTok to, quote, "manipulate content for censorship, propaganda, or other malign purposes," TikTok would try to comply with that order. But TikTok asserted that the government's concerns about data collection were made in bad faith. America is the only member of the G7 without a federal data privacy legislation or unified approach to data governance. TikTok and many other apps collect large swaths of data about its users, including device information, IP address, keystroke patterns, activity across devices, browsing and search history, etc., and location data. Now, this is my opinion, but if data collection is a national security threat, then maybe Congress should pass a data privacy law stopping Twitter and Facebook from collecting the same data as TikTok. Just a thought. But the Court of Appeals saw things differently. Quote, "That the act does not fully solve the data collection threat posed by the PRC does not mean it was not a step in the right direction." And the court quoted liberally from the government's brief, stating, quote, "As Assistant Director of National Intelligence, Casey Blackburn explained, the PRC is the most active and persistent cyber espionage threat to the US government, private sector, and critical infrastructure networks. Its hacking program spans the globe and is larger than that of every other major nation combined. The PRC has pre-positioned itself for potential cyber attacks against US critical infrastructure by building out offensive weapons within that infrastructure. Consistent with that assessment, the government has found persistent PRC access in US critical telecommunications, energy, water, and other infrastructure." And the court noted that a bipartisan group of legislators concluded that China tracks user data. Quote, "Of particular relevance to the government's first justification for the act, the PRC has engaged in extensive and years-long efforts to accumulate structured datasets, in particular on US persons to support its intelligence and counterintelligence operations." So the court found that the government's 2 national security justifications were compelling state interests. And it's not surprising that the court deferred to the federal government's judgment about the severity of the national security threats. However, that's only the first part of the strict scrutiny test analysis. In part 2 of the test, the government has to show that the law is narrowly tailored to that interest, or that it's the least speech-restrictive means available to the government. But TikTok proposed a number of less speech-restrictive options that they argued could have satisfied the government's goals without burdening speech. Quote, "These include disclosure or reporting requirements, the government using speech of its own to counter any alleged foreign propaganda, limiting TikTok's collection of location and contact data, and extending the ban of TikTok on government devices to government employees' personal devices." But the court rejected these options, instead agreeing with the government that data collection and content manipulation are not the type of harm that can be remediated by disclosure. Traditionally, the remedy for speech we disagree with is more speech. That's a foundational aspect of the First Amendment. But here the court rejects this principle entirely. Quote, "The idea that the government can simply use speech of its own to counter the risk of content manipulation by the PRC is likewise naive." The court said, quote, "The petitioner's attempt to frame the use of government speech as a means of countering alleged foreign propaganda is beside the point. It is the secret manipulation of the content on TikTok, not foreign propaganda, that poses a grave threat to national security. No amount of government speech can mitigate that threat nearly as effectively as divestiture." The court also dismissed the TikTok creators' argument that the government could achieve its goals by banning TikTok from collecting the data. Quote, the data collection risks identified by the government include the PRC's ability to use TikTok for bulk collection of data and for targeted collection on individuals. But frankly, it's possible that the court is the one that misunderstands the bulk collection risks, not the TikTok creators. Lots of websites and social media platforms collect the same information about its users, and sometimes more. Again, the US does not have a comprehensive data privacy law, and the court says that the government can't monitor what TikTok does, so it would have no way of knowing whether the app complied with the data collection regulations. As a result, the court says the only option that would meet the government's goals is full divestiture. But frankly, divestiture wouldn't even stop the data collection practices either. Say, for example, that ByteDance did sell the app to somebody else. That app is still free under American law to collect all that information and sell it. That means the law is wildly under-inclusive. And the law doesn't even apply to American companies like Facebook, which arguably has worse data collection and privacy practices than TikTok does. And TikTok also argued the law is over-inclusive, which means it includes more people and entities than it needs to achieve the law's purpose. The act applies to, quote, another ByteDance product, CapCut, that can be used to edit videos on various platforms, including TikTok, but does not collect user data or present an opportunity for PRC manipulation of content. But the Court of Appeals concluded that everything related to ByteDance is theoretically just as harmful as TikTok. And as for TikTok's free speech argument, the court said that the government is actually furthering free speech rather than hindering it. A foreign government threatens to distort free speech on an important medium of communication. Using its hybrid commercial strategy, the PRC has positioned itself to manipulate public discourse on TikTok in order to serve its own ends. The PRC's ability to do so is at odds with free speech fundamentals. Indeed, the First Amendment precludes a domestic government from exercising comparable control over a social media company in the United States. Here, the Congress, as the executive proposed, acted to end the PRC's ability to control TikTok. Understood in that way, the act actually vindicates the values that undergird the First Amendment. But I guess at least the court acknowledged that the act frequently referred to the content of TikTok speech. Quote, in fact, the government identifies a particular topic, Taiwan's relationship to the PRC, as a significant potential flashpoint that may be a subject of the PRC's influence operations, and its declarants identify other topics of importance to the PRC. And yet the court agreed with the government that, quote, the act is not an effort to control the flow of ideas to the public. But TikTok lost in the Court of Appeals and then appealed to the Supreme Court. The justices agreed to fast-track the briefing and held arguments on January 10th, 9 days before the law was set to go into effect. See, when the Supreme Court wants to fast-track something like a private business interest, they can. But it's good that they took 2 years to decide US versus Trump, because that obviously wasn't as important as a dance app. Now, obviously, if you're operating a social media network, you'll want a good lawyer. But if you want a great lawyer, my law firm, the Eagle team, can help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying your information might have been leaked, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. Because it's so important to talk to a lawyer right away so you can maximize your recovery. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. And now the Supreme Court has upheld the Protecting Americans from Foreign Adversary-Controlled Applications Act, clearing the way for TikTok to be banned in the US on Sunday. The court ruled that the US government has a compelling interest in protecting sensitive user data from potential misuse by foreign adversaries, particularly the Chinese government. TikTok apparently poses a significant risk to American citizens because of ByteDance's ties to China, which could enable unauthorized access to personal data of US users. The Supreme Court ruled, quote, there's no doubt that for more than 170 million Americans, TikTok offers a distinctive and expansive outlet for expression, means of engagement, and source of community. But Congress has determined that divestiture is necessary to address its well-supported national security concerns regarding TikTok's data collection practices in relationship with a foreign adversary. For the foregoing reasons, we conclude that the challenge provisions do not violate petitioners' First Amendment rights. Now, the first takeaway from this opinion is that the court found that the act was a content-neutral restriction. A restriction is content-based if it regulates speech because of the subject matter, idea, or message being conveyed. Several US lawmakers expressed concerns about Chinese propaganda when they drafted the act. However, the court did not consider evidence suggesting that the act targeted certain viewpoints. Quote, we are especially wary of parsing Congress's motives on this record with regard to an act passed with striking bipartisan support. Now, bipartisan legislation is rare, but that doesn't say anything about whether something is constitutional or not. Now, the court ruled that the government, quote, had a content-neutral justification for the act, quote, preventing China from collecting vast amounts of sensitive data from 170 million US TikTok users. Now, content-neutral laws are generally subject to intermediate scrutiny, which, as we discussed, is less rigorous than strict scrutiny. And just like the DC Circuit, the Supreme Court, quote, assumed without deciding that the challenge provisions fall within this category and are subject to First Amendment scrutiny. So they engage in a First Amendment analysis, just not strict scrutiny because they claim it's content neutral. Now, the second takeaway from the court's opinion is that the act apparently balanced the government's national security interest with petitioners' First Amendment rights. Quote, the act's prohibitions and divestiture requirements are designed to prevent China, a designated foreign adversary, from leveraging its control over ByteDance Limited to capture the personal data of US TikTok users. This objective qualifies as an important government interest under intermediate scrutiny. Now, how does the act protect the First Amendment rights of the petitioners, including TikTok and Americans who use the app? Well, as to the company's rights, it doesn't impose an outright ban, meaning the company can still operate in the US if it satisfies the conditional divestiture requirement, meaning its parent company has to divest. And as for TikTok users, the act does not prevent users from expressing their ideas through other platforms or means. It targets the operational structure of TikTok, not the ability of users to create and share content. And if TikTok is no longer available, users can post the same content to other platforms. I am not saying I agree with it, I am saying that's what the court's rationale was. The Supreme Court took the government's security rationale seriously, apparently more seriously than President Biden or incoming President Trump, which we will discuss. The court deferred to Congress's determination that the threat was real. Quote, sound policymaking often requires legislators to forecast future events and to anticipate the likely impact of these events based on deductions and inferences for which complete empirical support may be unavailable. And here, apparently, the government's TikTok-related data collection concerns do not exist in isolation. The record reflected that China, quote, has engaged in extensive and years-long efforts to accumulate structured data sets, in particular on US persons, to support its intelligence and counterintelligence operations. And the court believed Congress when it said China is gathering information on US users for nefarious purposes. The government cited Chinese law, which compels companies to turn over information if China demands it, as proof that TikTok posed serious dangers. Now, other applications also hoover up large swaths of American user data, but the court said this case should not be interpreted as limiting what those apps can do with your data. Quote, while we find that differential treatment was justified here, however, we emphasize the inherent narrowness of our holding. Data collection and analysis is a common practice in this digital age, but TikTok's scale and susceptibility to foreign adversary control, together with the vast swaths of sensitive data the platform collects, justify differential treatment to address the government's national security concerns. Now, the government made bold claims about the Chinese government's ability to control messages on the app by manipulating the TikTok algorithm, but the Supreme Court sidestepped that issue. Quote, the record before us adequately supports the conclusion that Congress would have passed the challenge provisions based on the data collection justification alone. So that's it, the law goes into effect. But what happens now? Well, President Biden has the power to grant extensions under the act if certain requirements are met, but instead Biden has just announced that he will just not enforce the law, which is cool. I didn't know a president could do that, because of the whole take care clause of the Constitution, which requires the president to faithfully execute the laws of this country. But President Hot Dog Man, who signed the bill into law, says that he will not impose any fines on TikTok during the last few days of his presidency and will just let incoming President Trump deal with it. So that's fun, which is odd because the entire rationale for the law is that this is about dire national security concerns. Now, Trump has indicated that he will also sign an executive order that also refuses to enforce this law. But again, generally speaking, the president doesn't have the authority to just not enforce valid laws that have been passed. But whatever. What even are laws? Like many of you, I probably spend way too much time on TikTok, time that I'd rather spend learning new things and getting the same gratification that I get while swiping through videos. Which is why even before the TikTok ban, I've been using an app that actually improves my understanding of practical human psychology, economics, philosophy, and history, which are topics that I'm actually deeply passionate about. The app is called Imprint, and they were kind enough to sponsor us without knowing they'd be attached to a video about the end of TikTok, an app they specifically designed their software to be a meaningful alternative to. It comes as no surprise to me that Google awarded Imprint the prestigious title of App of the Year, and Apple named it an essential education app. That's because Imprint changes your habits around learning. Imprint breaks down complex topics into interactive bite-sized chunks that are highly visual and designed to give you the same feeling of satisfaction you would get when scrolling through TikTok or Instagram. But unlike mindlessly scrolling through TikTok, spending time on Imprint will actually build your mind through engaging visual lessons. I'm currently working my way through interpersonal dynamics, the psychology of human relationships, as well as essential philosophy, theories, and tinkers. And I think I'll do the Read People Like a Book course next. And the best part is Imprint is designed to make you feel good about what you're learning. So whenever I have a few minutes of downtime in the day, I now feel compelled to load up Imprint instead of feeding my old doom scrolling habit. So right now you can click on the link that's on screen or down below in the description to get an exclusive offer to save 20% off the annual membership. And you don't have to commit right away because you can also use this link for a free 7-day trial. So click on the link or scan the code to start your free 7-day trial and get 20% off your annual subscription. And once you've done that, click on the link over here for more LegalEagle, or I'll see you in court.